Welcome back to the deep dive. This is where we give you the crucial context, the surprising facts you need to really get your head around the most complex issues of the day.
That's right.
And today, you've brought us a stack of sources that tell two very, very different stories about controversy. One is all about public image, and the other, well, it's about actual physical destruction and a major legal fight.
It is. And our mission today is really to be laser focused on extracting the legal truth from all this. We have to get beyond the media squabbles and dive right into the specific statutes, the procedures, the administrative law that brought a lawsuit to an emergency hearing in D.C.
So, what laws actually protect our national landmarks? And what happens when the executive branch just allegedly decides to ignore them?
That's the court question.
Okay, so before we get into the courtroom, let's just quickly touch on a piece of the political noise from the sources, just to set the atmosphere. We saw these reports of a media spat. It was between Fox News and the Midas Touch podcast.
Right. And this is the kind of, I guess, distraction that often fills the airwaves. It's all about perception, not policy.
Exactly.
The initial thing, as it was reported, it centered on Donald Trump's bruised and bandaged hands.
And the official explanation for that was just that he was shaking, quote, so many hands.
Right. And then you have the podcast hosts who, according to the sources, questioned that explanation. And this sparked a whole series of counterclaims from Fox News.
They said the hosts were suggesting it was due to some kind of weird, wacky disease or even a zombie-ish thing.
Yes, and Fox's response was basically to pivot and suggest that critics should be focused on perceived issues with President Biden's actual mental state instead.
It's just pure political theater.
Completely. Both sides are trying to frame public presentation, health, and trying to deflect or gaslight the narrative, as they say. We're just reporting it as context for the really intense political climate here.
Absolutely. Okay, so that's the noise. Now let's focus on the action. The thing that prompted a real emergency legal response. We're looking at a decision that led to the literal demolition of a wing of the White House.
All for a pet project.
A highly controversial one. And this is where, as you said, the procedural failures become physically tangible.
Exactly.
So the main event, it happened, in late October 2025. It was really swift.
Incredibly swift. The sources all confirm that at the express direction of Donald J. Trump, the East Wing of the White House was demolished.
Just gone, all to clear the land for his planned golden ballroom.
And the scale of this is what really shocked people initially. The East Wing, specifically its colonnade, held so much historical weight. A version of that structure went all the way back to Thomas Jefferson's presidency.
And that whole thing was just obliterated. Days.
In a matter of days. And the replacement he's planning is staggering. A new ballroom, they're saying it could be over 90,000 square feet. So this isn't a renovation.
No, it's an erasure.
A rapid, complete erasure of a historic federal asset.
Okay, so this action, being so disruptive and sudden, it immediately drew a federal lawsuit. But the group suing, this isn't just a random interest group.
Not at all.
The suit was filed by the National Trust for Historic Preservation. Why is that specific organization so important here?
It's absolutely crucial. Because the National Trust isn't just your standard nonprofit. It's a private charitable corporation. But it was chartered by Congress.
By Congress itself?
Yes, back in 1949. So Congress specifically empowered this organization to support national preservation and, critically, to facilitate public participation in these matters. They are, in a way, Congress's designated watchdog.
And who are they suing? It's not just the president, is it?
No, the lawsuit is sweeping. It names Donald J. Trump, of course, but also the federal agencies that are responsible for this kind of oversight.
Like the National Park Service.
The National Park Service, the Department of the Interior, and the General Services Administration, the GSA. And the core accusation against all of them is identical, a wholesale violation of process.
So let's unpack that. What did they allegedly skip? What are these mandatory hurdles that were ignored?
They allegedly skipped all of them. The demolition, the construction, it all went ahead without seeking formal approval from Congress.
Okay.
Without the mandatory review from federal commissions that oversee this kind of thing. And crucially, without conducting any of the required environmental studies.
And no public input.
Fundamentally, they denied the public any opportunity for input whatsoever.
And that denial, that seems to be the core legal violation here.
Precisely. The legal challenge has this quote in it that just cuts right to the heart of the matter. It says, "No president is legally allowed to tear down portions of the White House without any review whatsoever. Not Trump, not Biden, not anyone else."
So it's not a political debate, it's about whether the executive is above the specific federal
Yeah,
laws.
exactly. Are they above statutes that are designed explicitly to protect public property?
And the lawsuit hinges on some specific violations of these big administrative statutes. We're talking about the Administrative Procedures Act, the APA, and the National Environmental Policy Act, NEPA.
Yes, and if you connect those laws to what happened, their relevance is just crystal clear. The APA, it governs how federal agencies have to operate. It demands transparency, documentation, public participation for big changes.
Right.
And NEPA, well, that's like the environmental conscience of the federal government. It mandates that agencies have to assess all the environmental effects of what they're planning to do.
Everything from wildlife impact to hazards.
Yes, exactly.
Yeah.
To things like lead paint or, in this case, asbestos. And you have to do that before you touch anything. To allegedly ignore both of those, well, it suggests a pretty calculated effort to evade scrutiny and just rush the project through.
And there's also a fraud claim in there, which suggests this was, a deliberate attempt to mislead the plaintiffs.
That's right. The trust's lawsuit alleges fraud. They claim the administration initially promised they would get approval, said they wouldn't touch the structure without a review.
But then they just did.
Then, without any warning, no communication with the trust, the East Wing was suddenly gone. And that's what forced this emergency lawsuit, just to try and stop the construction.
It really reinforces that narrative of speed and surprise over process.
It does.
Okay, so this brings us to what makes the legal side of this so fascinating. The internal legal history on presidential power over the White House. We're talking about the Office of Legal Counsel, the OLC.
Right. The OLC history is the real systemic nugget here. This whole question of presidential authority over the White House is tied up in the 1906 Antiquities Act. And for decades, the rule was set by a 1938 OLC opinion.
And what did that one say?
It explicitly stated that presidents cannot unilaterally just decide to do construction or demolition on this scale.
So for more than 80 years, the rule was clear. You need outside approval. But our sources say that recently changed.
It did. Just a few months ago, the OLC produced a brand new opinion that completely reversed that 1938 stance.
Wow.
The new opinion basically just gave a green light. It said, oh, sure, presidents can do this, no problem.
And why is that sudden reversal, that change of legal opinion, so bad for the administration's case right now?
This is where the Administrative Procedures Act comes right back in. Specifically, what's called the arbitrary and capricious standard.
Okay.
The APA basically says federal agencies can't make these huge sudden changes in policy without a really good documented reason. A complete 180 on a decades-old standard, especially when it's so convenient right before a massive demolition.
It can be challenged in court.
Successfully challenged as arbitrary and capricious. It suggests the decision was politically convenient, not based on a consistent legal reading. And that just undermines their whole defense.
That frames the legal battle perfectly. So now the administration is facing this emergency hearing before Judge Richard Leon. He's a George W. Bush appointee, and the sources describe him as smart and law-abiding.
And the judge is significant. Because regardless of his ideology, a federal judge's job is to uphold the law. And the claims here, skipping mandatory steps required by Congress, like environmental studies, those are serious procedural violations. The law on process is much clearer than the law on, executive power.
Now, the administration is expected to argue that it's just too late.
Right.
They'll say the demolition's done, there's a huge crane on site, so the Corps should just let it continue. What's the counter-argument to that?
The counter-argument is all about the remedy, which is an injunction. If Judge Leon imposes an injunction, a freeze on all construction, the administration would be legally forced to go back and do all the required studies and public input processes they skipped.
And that would take time.
A lot of time.
Yeah.
The process is designed to be lengthy. It would likely take so long it could potentially run out the clock on the current administration's term. So that threat of forcing them to follow due process is a very powerful tool against the too late argument.
Let's pivot to a key hurdle in any lawsuit like this: legal standing. Is the National Trust actually harmed enough to sue?
The defense will absolutely argue they lack standing. They'll say the trust wasn't directly harmed. However, current case law, even if some conservatives, detest it, it recognizes an environmental injury can grant standing.
Even if the injury is generalized.
Exactly. But the National Trust has a much stronger case than that.
How so?
Their strength is in their congressional charter. Congress gave them the specific duty to facilitate public participation. When the administration denies that participation and destroys a landmark, the trust is being directly prevented from carrying out its mandated purpose. The harm is specific to their mission.
And this is where the whole thing moves from being a technical legal error to an immediate public danger. The environmental injury, we found out, it's not just about losing a historic building.
No.
What was the specific acute danger that the sources found?
This is the critical punchline that shows why NEPA exists in the first place. The sources detail that the East Wing was built using asbestos as a main construction input.
Oh, wow.
And because of the extreme rush, because they allegedly skipped the environmental impact reports, which would have mandated a whole mitigation plan, there appears to have been zero asbestos abatement done.
So wait, the failure to file paperwork didn't just cause architectural damage. It created a verifiable, immediate physical threat to people.
That's exactly.
Yeah.
Witnesses reportedly saw visible asbestos clouds after the demolition started.
Clouds of asbestos.
Yes, and this just elevates the entire issue from a dispute over architecture to a crisis of public health and safety. The workers on site, White House staff, maybe even the nearby community could have been exposed, raising the long-term risk of contracting mesothelioma or other cancers.
And the sources say the risk was made even worse by their choice in labor.
Yes. The sources claim the administration refused to hire union workers. Those workers would have followed the strictest safety protocols for handling hazardous materials like that. Instead, they opted for speed without proper mitigation.
That haste, that refusal to follow safety standards, it could have potentially lethal consequences.
It could, and it connects directly to the characterization you see in the sources. The plaintiff's filing describes this whole approach as being so Trumpian.
Right, calling it reminiscent of a failed bankrupt, multi-time bankrupt real estate developer.
Prioritizing personal vision and speed over legal process and, well, worker safety.
That really captures the stakes.
It does. This deep dive shows that precarious intersection of presidential power, administrative law, and the public's ownership of our national property. The core issue before Judge Leon is, can a president successfully argue the White House is essentially their private property under their sole authority?
And by doing so, bypass laws designed for public input, for historic protection, and most acutely, for public safety.
That's the question.
So, if we boil it down, what are the three nuggets that make this legal battle really stick in your memory? First, for me, it's the shocking speed of the demolition. The East Wing, linked to Jefferson, just gone in days.
Second, I'd say it's the fundamental nature of the legal violation. The accusation that they deliberately ignored cornerstone laws like the APA and NEPA.
And third, the one that's just terrifying, is the specific health hazard revealed by that failure. The environmental injury isn't hypothetical. It's the verifiable site of asbestos clouds, proving why we need the very steps that were allegedly skipped. So if procedural steps like NEPA and the APA exist specifically to slow down and scrutinize executive decisions to ensure safety and public input, what is the proper balance between efficiency and assurance to the democratic process when the property in question belongs to all of us? And furthermore, if the administration's whole argument relies on that newer OLC opinion granting this vast unilateral power, does an honest adherence to the law require Judge Leon to prioritize procedural consistency over executive convenience? That's something for you to mull over until our next deep dive.